Your government has announced a new courts precinct. It will be a private development leased back onto the Courts Administration Authority. We congratulate you for moving things along. However, it's probably going to be at least 5 years until we walk into that new courts precinct, and knowing building projects as I do, possibly longer. Are there plans to improve the courts facilities in the short term? That is to say, from now until we get to the courts precinct. This is a question for both of you. While it is acknowledged that the new courts precinct is in the pipeline, the judiciary has repeatedly called for IT upgrades to bring the courts into the 21st century. Do you have any plans to update the courts' antiquated infrastructure? If so, what do you propose?
I'll try and put through this as quickly as I can. First thing is, I think we will get to the position where within a month or so we're going to have 3 finalists for the tender of this thing, so it's moving along at pace, and I would think 5 years is a pessimistic estimate, and for those who work for the judiciary here, I really hope we do better than that. But anyway, that's one thing. Second thing is this, both in terms of computer technology and in terms of physical infrastructure, we are working on the basis of maintained in a safe and functional condition, but don't expect to, I mean, after all, why would you get an old car and stick a brand new engine in it? So what we're talking about doing is maintaining the functionality of what's there. In terms of the Samuel Way building, for example, that means constantly going around and stopping the gargoyles falling off and adding bits of cement here and there. So there's works going all the time. But the substantial upgrade in the ICT is part and parcel of that process, and it's an integral part of that process. That is the new court building.
Mr. Wade.
We know from the annual report of the Courts Administration Authority that Chief Justice Kourakis believes that the quarter-century-old computer systems used by the courts have a high risk of failure. He says not only does the courts need to maintain services, they need to achieve the required budget savings, and you can't get the benefits of the new courts without it. The Liberal Party announced recently that if we were elected on the 15th of March, that we would look at the PPP process, where it is at, if we are elected on the 15th of March, and assess the opportunities to expand the project to include IT. It's already there. And now this is IT system development. This is not just the, shall we say, the wires on the wall. And I suppose it showed that it's not there. The government's response to our suggestion that the system development be included in the PPP bid was the claim that it would cost $51 million. Now, to show you that the government isn't willing to invest that money, I'd encourage you to go to the Labor Party Liberal costing site, because there is the $51 million that they say they need that is needed for courts IT upgrade. They're putting it on our costings. They're putting it on us to find the savings to fund those. Clearly, they're not willing to commit. The fact of the matter is that we can't not address the IT backlog. We think the development of the courts precinct at the same time as you're doing not just shall we say the IT fittings, but the whole system design is a great opportunity to drive efficiencies in both sectors. It may well lead to changes in the building project. It may well lead to changes in the IT project. And to highlight how risky the current state of the court's IT is, we only need to remember what happened in 2011. Under the South Australian Labor government's stewardship, we had a computer malfunction in the justice sector system that led to 4,000 drivers not receiving their former disqualification notices, and a further 10,700 not receiving licence demerit point warning notices. You may not be aware, but in New South Wales, the government there was forced to pay $2.7 million in compensation after its court system gave out incorrect bail details and led to dozens of wrongful arrests. We believe that the opportunity that the PPP project offers to bundle up the services and take, if you like, seize the opportunity to upgrade our IT is a good one. one PPP project that is indicative of that is Citylink. Now, admittedly, it's a transport project, not a ports project, but the government tendered out that project for both the IT, the e-tag system, and the transport bill. The IT system was so forward-looking, if you like, that the bidders were being asked to tender against specifications where the technology didn't currently exist. So in other words, they had to work out how to make an e-tag work. As I said, if we're elected on March 15, we'll look at this opportunity to try to address what the Chief Justice himself says is a high risk of failure. And at the time, the attorney said the Chief Justice's concerns were beyond dispute.
Mr. Jennings.
Yeah, look, just a couple of things. First of all, look, as far as I'm concerned, we are looking at the complete transformation of the technology as part and parcel of this project, and I think Stephen and I are basically talking about the same thing there. There is actually, however, a bit of a bogus notion floating around the place that if you encamp the words ICT and say them often enough, they'll solve all problems. This is not true. This is not true. ICT is an enabler, it's not a solution. It's not a solution. So if anybody is naive enough to think putting a bunch of new computers with GWIS apps on them in the courts or anywhere else is going to transform the system and make it efficient, that is completely wrong. It's like believing in fairies at the bottom of the garden. The truth is, you need to actually have a system which works properly. Okay, it needs to be an efficient system. All the ICT does is automate the system. If it's a clunky system, you're automating a clunky system. So the real solution here is not the enabler, it's the system. And that is why, as I've said before, we have this justice reform project going, which does involve the courts, does involve the police and the DPP. I mean, I don't want to take up too long here, but I mean, those 6.4 adjournments, which, as I say, is comparing apples with apples in the district court. How many of them are caused by, for example, a late subpoena being issued by the Defence Counsel, which requires an adjournment to be sought by prosecution? Now, is that good? Is that bad? Has anyone ever sat down and had a talk about that? I don't necessarily have a view about that at all. But how many times do things go off the order for reasons that, if we looked at it in a holistic fashion, are not good reasons and probably not the court's fault?
Look, no one's suggesting that IT in and of itself is a silver bullet, but you're not denying that we need an upgrade.
Absolutely.
Absolutely. And that will improve.
Well, it'll make whatever you've got happen. It will automate whatever you've got. If whatever you've got is hopeless, it'll automate something that's hopeless.